White Houses, and I worked closely with the White Houses because I handled their presidential nominees, they were always incredibly supportive of the government ethics program. In fact, in terms of my day-to-day interactions with them, I couldn't distinguish between the experience with the Bush administration and the Obama administration. So with that context, this past 8 months, and I say 8 months because my work with this administration began during the presidential administration, has been an absolute shock to the system. And I would say that we are truly in an ethics crisis right now. And something's got to be done about it. And that's partly why I left, because I'd reached the end of what I thought I could achieve there. And one of the things I want to work on outside is proposals for improving the government ethics program. In addition, I think that the crisis we're facing was experienced very acutely in the government ethics program, but it's part of a broader assault on the institutions of our representative form of government. And so I hope to broaden my focus in my new job. In order to talk about how I think we have to address the ethics program in the executive branch, I want to give you a little bit of a primer on that ethics program, because it's important to understand what we're talking about when we say the ethics program. It's really made of three components, and that's the rules and regulations that set the absolute bare minimum floor for what you have to do in order to not be a criminal or not be a civil violator or not be a rule breaker. And so they are not as overburdensome as they could be if we were trying to say, here's what you should aspire to. There's also ethical principles and ethical norms. So you've got the rules and regs, ethical principles, and ethical norms. These are three distinct but interrelated things that are absolutely essential to the functioning of that program. The ethical principles are a real actual thing. And I can hold this up because all you really need to see is this number, is 14. And they're written out. I printed this off of OGE's webpage. These 14 very specific principles come to us from an executive order that President George H.W. Bush issued way back in 1989 and tweaked it a little bit in 1990. But they actually are a separate and distinct part of the ethics program. They've been incorporated in OGE's rules, and there's a provision at the beginning that says wherever any of the individual rules don't apply, you apply these 14 principles to evaluate what can and can't happen. And a career government employee can actually be disciplined or fired for breaking those principles, even though there isn't a specific rule on the point. And rather than reading you all 14, I'll just give you a couple examples. I mean, there's the principle that you should not engage in public service for private gain. And an agency could actually fire an employee for misusing their official position to actually benefit someone that they're close to. You've got an impartiality rule that says that you've got to protect the government's operations by being impartial in your dealings with the public and with businesses. The president is not strictly covered in a technical legal sense by the standards of conduct that apply to federal employees, but they normally follow that, try to adhere to it as much as possible. And so an example of where we ran into some trouble is where the president started tweeting out about how everybody should go buy Eddie Bauer products because they had supported him in the election. That's a misuse of position. That's abuse of authority. And so even if it's not strictly illegal, it's a departure, and it's a problem. Another one of the ethical principles talks about disclosure of waste, fraud, and abuse. And we get into some tricky areas if you do an overbroad clamping down on what you call leakers, and you have the administration calling things leaks that are not at all leaks, like when OGE decides to fulfill its mission to communicate with the public about important matters of government interest. They call that a leak. Well, it's an official release, not a leak. Or when this week Anthony Scaramucci talks about going to the FBI or DOJ because somebody released his public financial disclosure report, which says public at the top and has a discussion of the release mechanism. So these are ethical principles, and the departure from them is every bit of a threat as any violation of a specific rule. There's also ethical norms. And I'm going to talk about why they're important a little bit later, but let's just talk about what they are. These ethical norms include the tradition that all of our modern presidents have followed in divesting their conflicts of interest. And that sets the tone from the top. When you don't do that, you run into problems. Another example is with presidential nominees. The law governing conflicts of interest that's going to apply to them when they come into government isn't a prohibited holding statute. There are some, but I'm talking about the main primary conflict of interest that applies to all of the nominees. And instead, it's a recusal statute that says if you have a financial interest in a matter that's going to be directly and predictably affected by it, you can't participate as a government official. So you could literally comply with that particular statute as the Secretary of Energy if you held Exxon and Chevron and BP and just sat at your desk with your feet up reading the newspaper all day. The problem is you can't run the Department of Energy that way. And so an ethical norm that has evolved is that OGE and executive branch agency ethics officials run the program as a risk management program. And they try to read the tea leaves as best they can, and admittedly it's more art than science, to predict what kind of matters are going to come up that a nominee is going to have to get involved in. And they reduce risk by having them divest it. For the first time ever, and I don't want to impugn all nominees in this administration. Some of them have been cooperative. But for the first time ever, we're having a number of nominees, or they're having a number of nominees at OGE who are pushing back on literally everything, and even some of the basic assumptions of the ethical norms that you have to divest things that are likely to be a conflict. One other example that I wanted to offer you was that last year, when I was the director of OGE, I managed to get through a regulation. And it wasn't intended as a last-minute rule change. We'd been working on it for a couple years, and the rules just move slow, but the regulatory process. But I amended the gift rules to say that even, the rules say you can't accept gifts, and then it gives some exceptions. You can accept gifts in these conditions. But I have the rule now saying employees should consider declining otherwise permissible gifts if they believe that a reasonable person with knowledge of the relevant facts would question the employee's integrity or impartiality as a result of accepting the gift. And it focuses on a number of factors that employees should consider, including whether the gift has a high market value, whether there's an appearance that the donor is trying to influence them, whether the person has interests that could be directly affected by the employee's specific duties, as opposed to just an interest in the agency's work generally. And this is an important one, and I valued this one the most, whether it would provide the donor with significantly disproportional access to the government. And so you have wealthy groups or organizations able to make donations in the form of come to our event, and here's a gift exception that says you can come to our event. Okay, well, it's perfectly appropriate to rely on an exception. But if you're consistently going to an event where you're only hearing one side's view on an issue, then they are buying influence, or at least appear to be buying influence. And the gifts really are more appearance-based than actual conflict-based, because the odds that you're going to change everything because you got one scallop wrapped in bacon is not likely. But we have to protect even the appearance of the government's integrity, and that is one of the ethical principles. And so this articulates a new ethical norm for the gift rules. Interestingly, by the way, that rule applies to the president, and that admonition applies to the president by statute. The problem is, it was never intended to be an enforceable rule because we don't want people relying on exceptions and then having their heads chopped off, and they lose their job because they relied on a perfectly acceptable exception, but somebody else's subjective analysis of this standard was different. So it's not literally enforceable in the sense of penalties, but it's trying to create a new ethical norm because it's values-based. And a lot of people talk about rule-based and values-based ethics programs. We absolutely have to have a rule-based program so that there's a floor. But this is an example of a values-based rule that tries to push the people to go further. And the problem with the values-based program can be that the question comes up, whose values? Well, by putting it in this regulation and putting employees on notice, we're saying this is a value of the government. This is the value you should adhere to. It's not open to just anybody deciding you can't or can do something. But you're only going to have that addition be effective if you have an administration sending the message that ethics really matters, that ethical norms really matter, and that people should adhere to these types of aspirational requirements. When you have an administration under the leadership of counsel to the president like Don McGahn, you have an attitude of bare minimum compliance, in my view. And so a rule like this is just going to fall on deaf ears. And I challenge them, and I hope they're able to meet this challenge, to show me an example of where somebody applied that value and decided to decline a gift, because that would be wonderful and they would deserve credit, this administration, for having achieved that. So make us all proud. Tell us you've achieved that. The problem is not confined to the ethics program, though. We're looking at broader society experiencing some of these problems. You have a president criticizing law enforcement officials, firing one and threatening to fire others, or implying that he's going to fire others, criticizing them publicly, as he's done Jeff Sessions, attacking the press, calling them the enemy of the people. Can I just tell you here at the Press Club, you are not the enemy of the people. You are a valuable institution that is part of what makes our country great. In fact, it was so important, it was the First Amendment that had to be added to the Constitution. And as I said before, going too far in cracking down on leakers could affect whistleblowing. And so, of course, we don't want people disclosing classified information. But again, when you have Ryan Lizza of The New Yorker reporting that Anthony Scaramucci was outraged that it was leaked that somebody went to a dinner, that's fairly outrageous. So why does it matter? It matters because norms are the glue that holds society together. And I heard a media personality who I respect yesterday on TV say, we should all stop talking about norms. Why norms? And I got her point. It sounds soft. And so maybe to communicate to a broader audience, I got to come up with a jazzier, more important, scary sounding word than norms. But they really are the rules that glue society together. So even if the word sounds sort of esoteric, the meaning is incredibly important. And I'll just give you an example of the simplest norm in our society. People see a crime being committed on the street, somebody being mugged, they call the police. It's an ethical norm. In most neighborhoods, in most parts of this country, people call the police when there's a crime, unless something has completely broken down in that neighborhood, which happens sometimes. But they're not usually legally required to do it. I read about a New England state once that had a $100 fine for the guilty bystander, and that sort of was what the Seinfeld episode was based on at the end of the series, where they got prosecuted for not acting. But in reality, that doesn't happen, and that's why it was funny on a sitcom. Yet, we can count on people adhering to that norm, and if that falls away, you'll have utter chaos. So that's why norms are really important. And I think what to do, my advice is to reporters in particular, report on departures from norms, not just strictly violations. And there's two reasons for that. One, a lot can slip away and a lot of harm can happen before you have an actual violation. And two, it reinforces this attitude that I perceive. Now, maybe that's not what is in their head, but I perceive Don McGahn, the White House counsel's office, adopting an attitude of bare minimum compliance. And you don't want to validate that kind of approach by only talking about violations. And then for my part, I've got a legislative proposal that I hope to be making. But just going back, and I guess I want to stay within time so you have plenty of time to ask questions. So maybe what I'll do is I'll talk a little bit about the legislative proposal. One of the ones, and this is my proposal at this point, I'm working with CLC and other groups. to try to refine it so that it's got more buy-in. But my personal thinking is that we need to clarify OGE's authority to make it clear that OGE has authority over the entire executive branch, which was the intent of Congress when they passed the statute. There was a case in '95 in the District of Columbia District Federal Circuit that called into question whether the White House is an agency for all purposes. I think people have missed the fact that posted on OGE's website is a form the White House filed this year in which they declared that they're a federal agency because they relied on a legal authority to accept outside contributions to cover their official travel that only applies to federal agencies, and only federal agencies are required to file that form. So it's at odds with a claim that they've raised that they're not a federal agency and therefore they're not covered by OGE's organic statute, which says that OGE has authority over every executive agency. So there's some inconsistency there. They want to be an executive agency when it means they can accept gifts, but they don't want to be an executive agency when it means they can be held accountable for ethics. That's a nice deal if you can get it. Increase OGE's authority to access and information. Increase OGE's access to information and records. I would like to see OGE have subpoena authority, and I'd like to see it enforceable by a court, if need be, if somebody ignores it. I ran into the experience recently where I was fighting to get waivers from the White House, and these are routine ethics requests. That's a routine oversight activity OGE conducts as the supervising ethics office for the executive branch. And I got a letter from Mick Mulvaney, the director of the Office of Management Budget, that he copied to every single general counsel and every single designated agency ethics official in the government. We're talking potentially hundreds of people, saying that OGE may lack the authority to this and they need to dig in deeper whether they should respond to this routine request. And obviously that's a very intimidating letter to send to agency ethics officials and general counsels because he's the person who controls their budget. And so I came back as hard as I knew how, and they wound up releasing the waivers. And then again, getting back to ethical norms, I discovered that 10 of them were unsigned, undated, and retroactive. And so, again, we have the departure from the ethical norms. I do think there should be additional investigative authority. I don't think it should rest with OGE, and that's where I differ from some people making recommendations. But having been on the inside, I think that the Office of Government Ethics performs a very important prevention role. And to perform a prevention role, people have to be willing to come to you and ask you for advice before they do things. When's the last time you went up to a police officer and asked if you could cross the street here in the middle? I mean, people are not going to go to the cop. So you have to separate. You still have to have that separation. My idea is there's a lot of entities in the federal government, agencies, the White House, whether, if they want to claim they're not an agency, we'll just call them the White House, and inspectors general themselves. These entities don't have, very small agencies don't have inspectors general. And so if there was one central inspector general for the executive branch who had jurisdiction over every office and employee in the executive branch who doesn't have an inspector general, that would plug all the gaps. And I'd like to have them have a special responsibility to OGE, where if OGE asks them to investigate something, they have the independence to decide whether to investigate it or not. But if they decline, I'd like them to have to notify Congress and OGE in writing of the reasons they were declining. And I think having to put your name to that would ensure that OGE had the support it needed, but the IG would have the independence they needed. Now, obviously, there'd have to be exceptions when it would interfere with an ongoing investigation or national security to release that. But in all other cases, I think it should be posted on the website. I think OGE needs to be more independent. Its director needs to be removed for cause only with 30 days notice, both to the director and to the Congress. And OGE needs legislative and budgetary bypass authority, which means it could talk to Congress without having to get permission from the White House or OMB. And there's nuanced rules. You can respond to letters from Congress asking you questions, but to just submit a legislative proposal or budget, you have to go to OMB first. I'd like them to be able to send those simultaneously to OMB and the legislative branch so that Congress could have the information it needed without having it filtered. I think OGE needs to be able to enforce ethics rules. I'd like to see it be able to initiate an action in court for civil penalties, unless the Department of Justice chose to initiate the action or to take over the action after OGE had initiated it. And I'd like to remove some overly burdensome due process procedures that establish way too complicated a mechanism for OGE to pursue recommendations of disciplinary action or to order people to stop engaging in things that violate the rules. OGE hasn't traditionally engaged in much of that because they went too far on the due process protections, and OGE can't do that work. I'd like them to tighten the revolving door by extending the restriction on post-employment for senior employees, senior officials, people at my level when I left the government, to 2 years instead of 1 year. And that would keep them from going back to their agencies to represent somebody for 2 years. I'd like to see a recusal obligation for anybody who comes into government and gets a special payment, something discretionary from an employer on the way in. Right now, it'd be illegal for somebody to give you a payment after you go into government for going into government, but there's a loophole. You can give it before their first day, and it's perfectly legal. And there's a regulation that carves out a very narrow swath. And this is technical. It applies only to party matters involving specific parties, actually engaged as parties in the matter. I'd like the recusal obligation to be statutory. I'd like it to come with civil penalties. I would like it to be so broad that it's any particular matter affecting the financial interests of the person who gave you a payment. And I'd like it to last at least 2 years, if not 4. And so that would presumably, I hope, deter people from giving you special payments because it means you're going to be sitting on the sidelines and not doing anything to help them. I'd like to see a 2-year recusal instead of 1 year for past clients and employers. I'd like to amend the Ethics in Government Act to prohibit public officials from receiving compensation for the use of their names or their families' names. I'd like to see an increase in transparency where certain types of ethics records should go on OGE's website and agency ethics officials' websites. But I don't want it to apply to every piece of advice they give, which I've seen some people call for. And my concern there is that OGE can't be the prevention mechanism and agency ethics officials can't be the prevention mechanism if they know that everything they say to you when they come for advice is going to be slapped up on the webpage. But I do think there are certain concrete actions that can be defined clearly, like waivers, any kind of authorizations, anything to do with ethics agreements or compliance with ethics agreements, anything to do with certificates of divestiture or training records, and any other kind of approvals like approval to accept a gift. And I would like to see a new disclosure requirement for a narrow set of people, the top layer of government. Technically, it's people covered by Section 13 of the Stock Act, for any lawyers out there who want to research that. But it's the top layer of government. I'd like them to have to disclose business liabilities of any business that they still have a large interest in. If they were recently an officer, director, employee of that organization, or if their family controls it, as long as it's a private organization. I'm less worried about publicly traded companies. I would like to free up some resources by removing the requirement to disclose income from publicly traded assets. Your average middle-class federal employee could fill out their financial disclosure report in 15 minutes, but having to look up how much they earn from a mutual fund or a stock that's publicly traded and go over each quarterly report, it turns it into a 2 or 3 hour affair. And I think that removing that requirement would free up a lot of resources of the ethics program to focus on more significant disclosure issues. So I'm not all more is more. There's one area where I think less is more. I think people have to disclose discretionary trusts. I would like to see that as a new requirement. Discretionary trusts are trusts where you're a beneficiary and the trustee has total discretion to give you a payment or not give you a payment. I'd like to, and right now, you don't have to disclose the underlying holdings of a trust like that. You don't even have to disclose that the trust exists. So for all we know, there could be plenty of people over the coming years who file financial disclosure reports, and maybe they're the beneficiaries of assets and have an interest in trying to advance those, but we're not going to know about it. So I'd like to see that as a requirement added to the disclosure rules. I'd like to salvage the blind trust program. You hear a lot about blind trust. Let me tell you the exact number that are in the executive branch: 0. So it's not hard for me to remember that number. The last one was Henry Paulson in 2006. And it's because the program's fairly unworkable and doesn't really solve the problems people are after. But if we could come up with a new mechanism that actually created blind trust, you'd have a whole new level of protection against conflicts of interest than we've ever seen before. And what I'd like to do is authorize managed accounts rather than trusts. You can walk into a financial institution right now and say, I'd like to sign up for a managed account. And somebody will buy and sell assets for you, and it's not going to qualify as a blind trust. But if we could have some requirements to ensure that you don't know what they're buying and selling, that would be so feasible to be able to just enter into it that you may even get to the point where you not only have top government officials entering into these things, but people at all levels. And I'd love to have a day where instead of reporting there are 0, I could report there are 4,000. And so that's one thing that I think could really make a change. One other change, I got 2 more. One other is having to do with special government employees, and this is something Senator Grassley has been pushing. It's currently his interpretation. While I was in the executive branch, I was bound by the Department of Justice's interpretation, and that is their current interpretation of the executive branch is if you're appointed as a special government employee, you can serve forever, for the whole year and show up every single day and still be a special government employee, as long as they had a good faith belief when they designated you one that you were only going to serve for 130 days or less. And then fewer ethics rules apply to you. I'd like it to be consistent with what Senator Grassley has said, to be that at 130 days you turn into a pumpkin. You don't get to be an SGE anymore. Instead of being a special government employee, you either have to leave or you become a regular government employee, and then all the rules apply. So either of those would be an acceptable outcome to me. And then, of course, I'd like to address, and this is the final one, presidential conflicts of interest. Now, these other ones I've talked about are sufficiently technical and bureaucratic, and I hope I haven't put you to sleep, but that I'm hoping they'll be non-controversial. This one, I get that we're in a hyper-polarized society right now, and so people will have a hard time from both sides of the aisle being able to take a look at this issue. But I think it's important because we've always been free of presidential conflicts of interest since the Ethics in Government Act was enacted, and now we're not. And you see the president flying around giving free advertisements to his properties. You see foreign governments and businesses and charities and even political officials holding events at his properties. And it's just inextricable, the conflicts of interest. So I'd like to have a prohibition on presidential conflicts of interest. It cannot be a recusal requirement like the existing statute. We need our president to participate in everything. But you could have a rule that prohibited the holding of assets, and it would need to have plenty of reasonable exceptions. I'd be okay with the president having more exceptions than even the rank and file employees, because this is unlike the other one, which is a recusal statute, an actual prohibited holding statute. Now, in terms of penalties, I'd like the penalty to be just you're a violator. You can't really impose penalties for this. There is an impeachment mechanism. There is, you could have a requirement that somebody just simply has to divest. That's the cure for violating the rules. You go and sell. But Congress already has a constitutional mechanism to address violations of law by a president. So it's enough that it says it's illegal to hold certain holdings. And I think we need to re-clarify that nepotism, the anti-nepotism statute applies to the White House. On the first day of this new administration, the Office of Legal Counsel and the Department of Justice rolled that back, and I think it's created some difficulties. So I'd like to see this statute amended to make clear that now, of course, there would have to be an exception for the president's spouse, but that should be the limit of it. So anyways, those are the types of things that I'd like to see happen, and I'm going to be working with various groups to see where we can find commonalities, work with the folks at CLC to see what they want to sign on to as the specific official position. And I just want to say I'm really looking forward to continuing working in this area and broadening my focus. The Campaign Legal Center is a terrific group. I hope everybody will go and check it out on their website now that I don't have a conflict of interest and I can talk about them. They are involved in an incredibly important litigation this year, and I should say we instead of they. And that's, they are leading the case that could put an end to political gerrymandering, which is the kind of thing that can transform a society. And the oral arguments are this October. So check them out. Follow this case. It's an incredibly important case. And let's keep our fingers crossed for an end to political gerrymandering. So.
So with that, we're going to open it up to questions. If you have a question, I would ask you to identify yourself by name and your news organization. So let's throw it open to the floor. Questions? Yes, in the back.
Chase Conner, Federal Computer Week. In the past, you've spoken out about the president's plan to place his holdings in trusts managed by his sons as insufficient. In terms of in terms of that plan and GSA lease specifically, do you think that that is settled at this point, or do you think there's action to be taken on that front? And secondly, what congressional avenues do you see as taking up the mantle on ethics issues?
Okay, so do I need to repeat the question for TV, or do they have sound?
We're going to have a handheld mic.
So, okay, great. So the first question was about the president's plan to set up a trust run by his kids and whether more needs to be done on that. I said it back in January and nothing has changed. It's worthless. It's meaningless from a conflicts of interest perspective. He still has a full financial interest in it, and it's not a blind trust. He just signed a financial disclosure report that lists his holdings. So not only he, but everyone in the world knows what they are. And so there isn't really more to be said about it, except what needs to be done is he needs to divest. He needs to sell those assets. The second question I just forgot.
The second question was, what congressional avenues do you see as taking up the
So he wants to know what congressional avenues do I see for taking up the charge of reforming the ethics program. Just this Monday, I had an excellent bipartisan call with Chairman Gowdy and Ranking Member Cummings from the House Oversight Committee. It's actually OGE's Oversight Committee, and we'll be working on their reauthorization legislation. And they both indicated they'd be open to reading a letter from me to describe the kinds of things I'm talking about now, which I greatly appreciate. It's you can send letters to people all day until you're blue in the face or your hands are tired from signing them, but it's wonderful to have people say they'd actually take the time to read it. And so I was very enthusiastic about our call. And so I'm hoping the two of them are interested. I'm hoping the Senate Oversight Committee for OGE, HSGAC, the Homeland Security and Governmental Affairs Committee, will take this up as well. If they pursue the reauthorization of OGE, of course, they will need to take a look at whether they're going to make changes to OGE statute. And I hope that the Senate will use any nomination hearing for any nominee to become the director of the Office of Government Ethics to talk about the president's conflicts of interest, ask any new nominee what their position on it is, and see if they can explore what some new nominee would endorse as a legislative proposal and whether they could count on that individual's support for strengthening this program.
Yes, in a second. Yeah. Could you tell us?
Carrie Levine from the Center for Public Integrity. You had mentioned earlier that there was a crop of nominees for this administration that really pushed back against counsel to divest from holdings. What was the outcome of that? You know, was it that they wound up being instructed to divest, that the agreements called them to divest, or, you know, was there a blunting of that? Are they divesting less than normally you would see? What was the outcome of that pushback?
So she asked about my comment about some of the I'm happy to report the outcome is good. And to their credit, every one of them ultimately did what we asked. It's just that I saw people in my hallways when I was working there walking out, literally slapping their foreheads. And the refrain they would all say is, why is everything a fight? And why are some questions being asked that have just never been asked before, along the lines of why do we have to do this? And again, it's not all of them. Some of them have been very cooperative. So the good news is I feel confident saying that during my time there, all of the ethics agreements are consistent with what we did before, and they're posted on OGE's website, so it's all public knowledge. I'm not talking any inside baseball here. You know, I hope they continue holding that line going forward.
Yes, Bob.
Sorry.
Bob Weiner, I'm Headliners member and also op-ed writer. I want to bring up two items that have been very hot in the news, and if you're comfortable answering them, that would be fantastic because of your perspective. Did you look at, or do you have an opinion on the president's potential financial history with Russia, including bank loans, including by a third party? And do you think that with him and members of his White House family team have an impact on their attitudes towards sanctions and policies versus Russia? That's the first question. And then the second one, which is hot in the news, is 200 members of Congress, led by Congressman John Conyers, the Dean of the House, have filed a lawsuit on emoluments on violations that they believe that the president has, including profits from the Trump Hotel, where he has foreign leaders and does fundraising. Is that, in your view, a violation of the emoluments clause of the Constitution?
Okay, so the first question was whether, while I was at OGE, we looked at financial interests of the president or his family related to Russia, and whether I think that's interfering with their judgment on Russia sanctions. I'm not keen on talking about individuals whose reports we may have looked at, so I can't really get into that. What I can talk about is the fact that the only information OGE has access to is printed right there on the public financial disclosure reports that are now out in the public and have been circulated. And so that's part of why I'm interested in changing the statute to allow for the reporting, or to require the reporting of certain business loans, because the financial disclosure form only lists the financial holdings that you have. Any liabilities are strictly limited to your own personal liabilities and don't extend to the liabilities of businesses, even if you're heavily intertwined with them through family control or past leadership and significant ownership interests now. So without even having to go into the individuals, what I can tell you is that kind of information just isn't available on the form. And of course, we don't have the president's tax forms as yet another departure from the ethical norms of our society, so there's even less information than in the past. As to what's in their heads, I try to refrain from speculating about people's intent, so I don't know. But I think the real problem is that you have to actually even ask the question, do these financial interests potentially influence Russia sanctions? And to me, and this gets back to the talking about ethical principles, ethical norms, and rules as three distinct components of the ethics program, right there, we're already outside the realm of ethical norms if a president is continuing to hold on to financial interests, and we have to ask the questions about what effect it's having on them. So the question itself is the answer, that we shouldn't have that level of uncertainty because it casts a cloud over all government decision-making. The second question was about the pending emoluments clause litigation. I think what I have to do, and this isn't an intentional dodge, is defer to the folks who are involved in that litigation right now. I'm not an expert in the emoluments clause, and while I was in the government, I avoided studying it closely because the Department of Justice speaks for the executive branch in matters of litigation, and so I didn't want to be articulating a viewpoint that was distinct from the Department of Justice's viewpoint on that pending litigation. I've only been out for a week, and I've been talking to a lot of you and getting settled into my new office. So I'll take a look at that issue, but I think it'd be premature. But again, it goes back to the question, we shouldn't be in the situation where we have to wonder, because if he didn't own these financial interests, we wouldn't have a question about the emoluments clause. And so when people say the emoluments clause is an arcane area that hasn't been explored extensively, and so it's very difficult for the litigants to cite precedents, it's because we haven't had to. Presidents have resolved their conflicts of interest, and so we've never been in this situation before to the extent that we are now, and certainly not in modern times. And so to that extent, I hope the courts, when they look at this case, will look at it with an eye towards realizing that the precedent itself may not just be found in court cases, but in the behavior of presidents who have been careful not to have financial interests that could raise these questions. That's not traditionally an area of legal consideration in all cases, but here where we have such an important constitutional provision and so little precedent, the court is going to have to go looking, and I hope the court will consider what past presidents have done with an emphasis on recent past presidents, because the norms of a society evolve over years, but you've got 40 years of history to look at right now. Oh, I'll let you pick it.
Yes, please.
Kate Ackley with CQ Roll Call. The recommendations that you have obviously would require action in Congress. Are there certain Republican lawmakers that you're going to be going to and trying to press these issues? Obviously, Democrats have unveiled a number of ethics and other types of overhauls, but you are not seeing that being embraced from Republicans. So is there certain lawmakers that you're going to look at to maybe take this up from the Republican side of the aisle?
So the question was, any legislative changes are going to need bipartisan support, essentially, and you know, folks in one party and on the Hill, the number of them had made proposals, but another hasn't. I absolutely agree. I mean, again, it goes back to one of the first things I said: ethics has no party, and we're really going to need both major parties in Congress to come together and make some of these changes. Now, as I said, except for the last one where I'm talking about presidential conflicts of interest, these should be no-brainers. This is the advice of an expert who's done this for years and years, and these rules will apply to future administrations. And at least so far in our country, the White House has passed back and forth between different parties, and assuming that continues, and I think it's a safe assumption using inductive logic, Congress should want to have a set of rules that will apply to people, because you know, a majority can be in the minority tomorrow. Well, maybe not tomorrow, but eventually. And so I'm hoping from there we build some support. I invite all members of Congress to talk about it. I was greatly heartened by Chairman Gowdy's interest in it. Senator Grassley has been a great advocate for good government issues. And in fact, I quoted him in the waiver dispute with the White House, and somebody on his staff said that the senator stands by the quote that I in turn quoted. So I'm confident that there are good people in both parties in Congress who care about government ethics. I got a letter from Congressman Walter Jones from North Carolina while I was in OGE, and my response is still on OGE's website, at least recently it was. And so he was expressing concerns about some of the ethics issues. So I'm 100% sure there are really good people in both parties in Congress who care about this. And the trick is going to be finding them, but I invite you to find me too.
I just want to follow up on that for a second. I recently attended a talk with a member of Congress who said that when he is talking to his colleagues, they're surprised by just how fragile the government is, that in the last 6 months, they didn't know how much harm can be done within the law. You've been talking about norms. I mean, is that your sense, and do you think that there's a growing sense that there's a need for more ethical reform on the Hill for those reasons?
I feel like I'm perceiving that sense of surprise in a lot of corners of our society, including from Congress. I can give you sort of a concrete example about that fragility, which goes back to the ethical principles and ethical norms as two additional components of the ethics program. much has been written recently about OGE having a lack of enforcement authority and how essentially weak it is in a lot of areas. And first of all, let me thank the press for caring. When I was nominated for OGE's director position, I said my goal was more public outreach, and I pretty much stood out on a street corner doing jumping jacks, saying, "Hey, look over here." And for the past 6 months or 8 months, people have been looking finally. So that's helpful. But those stories about how weak OGE is in a lot of ways are really important because OGE's only real source of power. I mean, there's authority and there's power. A court can say, do this and issue an order, but it's the U.S. Marshals showing up on your doorstep that are going to make sure you do that. OGE has no U.S. Marshals, so it gets its power as opposed to its authority from two sources that it leverages. One has always been the White House, and because every presidential administration, Republican and Democratic alike, have always been very supportive of OGE, for a teeny tiny little micro agency, OGE wielded incredibly disproportionate access to the White House and could call up the White House counsel's office and say, we're having a problem with this agency or with this person. And almost invariably the next day we'd get a call from them saying, what can we do for you? How can we help? Because the counsel's office had called them. Well, that went out the window this year. And then the only other source of leverage at all that OGE has is going public and talking to the public. And you'll see the incredible pushback that OGE has received from that. I've personally been smeared and attacked by this White House and its surrogates. And that's hard. And I'm scared that what they'll achieve is deterring other people from doing it because they don't want to suffer the attacks that I have. But it's important that OGE keep doing that, but it also highlights how incredibly fragile the ethics program is because those are the two sources of leverage OGE has, and beyond that, it has nothing.
Yes.
Jana Goldman, freelance. Building off of that, what can average citizens do in addition to maybe contacting Representatives Cummings and Gowdy to encourage ethics reform?
So the question is, what can average citizens do? And these words I mean with all of my heart. Participate in your democracy. Get involved. Talk to your members of Congress about how important ethics is, the ethics program in the executive branch, but also these other ethical norms or norms of our civil society that we're departing from. And that's why I'm sort of imploring the press today to think in terms of talking not only about specific violations, but departures from norms, because we've got to catalog and keep track of what's being lost so that we can hold on to it and rebuild it. And I don't mean that in any partisan sense whatsoever. This country, its norms, its ethics program have always been supported by both parties, and we're going to have to count on both parties to bring it back. You can also support through volunteering or donations to good government groups that are making noise, campaignlegalcenter.org, and then just writing letters or speaking out when you see norms departed from.
We have time just for a couple more questions. All the way in the back.
Brittany Aiken, Court House News. I want to piggyback off of what you just said and ask what your greatest concerns are about the departure from norms. And in terms of holding on to some of that and rebuilding, how easy or difficult do you think it will be to rebuild?
So the question is, what is the biggest concern about the departure of norms, and was it how easy will it be to bring it back, or difficult? And I'm extremely concerned, and the biggest concern is that norms evolve. So if we have a shock to the system, what we're experiencing now could become the new norm. All the more reason for it to be reported on and covered and challenged before it takes root. When something happens, like if Special Counsel Mueller gets fired, that will be an extraordinary crisis for our country. I don't even have the words for it yet, and I'm sad to say I'm trying to get the words together so I'll know what to say when it happens. But it shouldn't happen. It'll be destructive to our society in ways we can't even begin to fathom right now. And so the answer to how difficult it will be to change, the longer departure from norms persists, the more difficult they'll be to turn back. And so people have to be vigorous in holding on to the norms of our civil society and the institutions of our representative form of government, which includes the press. You're not part of the government, but our Constitution enshrines your role in our society in protecting our institutions.
Yes, please.
I think one,
I
for
could use it.
Joyce Winslow, and I was RAND Corporation's commentary editor, and I now write for a number of newspapers. I see you as the eagle in the coal mine. I guess I'm wondering, in a devil's advocate questioning kind of way, why you feel the American public who holds these values and norms in large part has not risen up on its hind legs. Why have they delegated this to our officials, such as you and your colleagues? Or do you think they just don't perceive it yet, that they think the democracy will survive this administration and it will go down?
So the question was, why aren't more people interested in protecting these norms and standing up and being heard? And you threw in the line, or do they just not see it? And I think that's a really important comment, because unfortunately our society is so hyper-polarized right now that people are seeing everything through a lens of you're for us or you're against us. But ethics is not for or against any party, and neither are our civil norms. And so we've got to find new ways to communicate with people. Now, I do disagree with the statement that that a lot of people are, and I'm not sure if you meant that, but a lot of people are not standing up. I think a lot of people are making noise, and I think one of the reassuring things is how much of our country does care. And you're seeing that in maybe not across the board, but in some corners on both sides of the aisle. And so I think people are waking up to the threat that's being presented to the nation that we've built here with the attacks on our institutions. And it should be cause for great alarm, in particular if Mueller loses his position. But I do think it's important to communicate about it. I think it's important to try to talk in ways that are not partisan, because you have to invite people into the discussion, and we have to do a better job of hearing each other in this country. We're not listening to each other, we're not looking at each other, we're not reading each other's news. Let's try to open our minds. And so for my part, I've been trying to stay focused on issues that pose threats to our institutions, less talking about political issues. Somebody asked me about healthcare recently. You know, as a private citizen, I have some views, but I'm trying to stay focused on the specific challenges to our institutions, because I think there is crossover there where people from both parties care about our country and its institutions and can come together in trying to reinforce that.
We'll take one last question, please.
In reading all the financial disclosures, this administration has nominated some extraordinarily wealthy people who use private companies that are difficult to penetrate. In some cases, it's very difficult to tell from the financial disclosures what the underlying assets are of a holding company, or where conflicts might arise. It's hard to look at a shell company based in the Bahamas and say, oh, I see where the conflict is.
Right.
So I noticed that recently, when Mr. Kushner refiled his amended forms and Ms. Trump filed her forms, there was a more extensive disclosure of underlying assets in the end notes. And so I'm wondering how OGE is planning to deal with this. I think in some cases, not to single people out, but in the ones that have been publicly filed, Mr. Ross, for example, had companies that made it very difficult to tell what the underlying assets were. This has come up a few times in this administration because you're dealing with very wealthy people. How does the public evaluate that? How does OGE evaluate that if they're going to continue to maintain stakes in some of these holdings and it's difficult to tell what the underlying assets are, or the business partner?
So if I can summarize and tell me if I get it wrong, it's basically there are a lot of really wealthy people coming into government now, and when you have tiered holdings with multiple shell companies, it can be hard to get your mind around what the underlying holdings are and how do you evaluate conflicts. That's a very significant problem we're facing. One of the reasons for public financial disclosure reports to be public, contrary to Mr. Scaramucci's comments in the past 36 hours, is so that the public can dive in, and there are financial experts out there. One thing I'd say, and this goes back to the question of what can average citizens do, if you're a financial expert or you're somebody who has some knowledge about something that you've acquired legitimately through your job or type of work, and are at liberty to share it, you can, for instance, write to the Office of Government Ethics or write to Congress and share your views. I mean, that you've got a First Amendment right to communicate with government officials, and or even just go to the press, let them deal with it, because that expertise is incredibly valuable. And it's essentially crowdsourcing conflicts analysis, dating all the way back to 1978 before anybody thought of that term, I think. And so that's one thing. The other thing is it is very hard. She asked a question about one particular report that's been revised, and I can't comment on that because I worked on it, but what I can say generally is that the review process at OGE tends to shake out information that wasn't disclosed before because the disclosure rules are incredibly complex. And as part of that process, OGE talks to agencies or the White House about how they're managing these conflicts of interest. And so that is built into the process, and one of the best mechanisms is to ask the filer or ask the agency what the conflicts are, particularly an agency that has very technical issues like the Securities and Exchange Commission, because they have more expertise than OGE in that specific area, which is why we have sort of a decentralized ethics program with 70 or 80 people at OGE and 4,500 agency ethics officials working out at the agencies. It's not a perfect process, and I think sunlight being the best disinfectant, the cure is to have people from all walks of life study these forms, and particularly people with financial expertise speak out if they see something.
So I know that in the federal government, gift giving creates a lot of questions, but fortunately, now that you're in the nonprofit sector, we hope that you will accept as a token of our thanks this National Press Club month
thank you
for
very
being here
much.
today. And with that, thank you everyone for being here, and thank you those that are viewing at home. We're adjourned.
Thanks a lot. I really enjoy that mug now that I can take things. So,
Thanks for your great answers to the
oh,
questions.
thanks. Did no? Huh? Interesting.
Hoping we can have a cup of coffee.
Oh yes, yes.
Can I get your card?
You know, they just gave them to me this week, and I haven't got them, but I can give you the email address.
Yeah.
Maybe I'll give it to you.